Yes, I did.
Okay. We'll talk about that after you go ahead and talk to Dr. Vieira.
Okay, so the remaining fact was that the Secretary of State was alerted to a significant problem with the certification of live birth as provided by Senator Obama as early as August 8th, 2008, well ahead of the primary election. And the response that I received from the Secretary of State's office was, we declined to investigate the complaint because the complaint is not yet ripe. And so they declined to accept the complaint on basis of ripeness prior to the primary. I reaffirmed it by certified letter 3 days following the primary. The complaint was completely ignored following the primary. And then, of course, we brought the lawsuit based on the statute that I cited to you before, allowing a registered voter to sue if the elected official was not eligible to assume the office following his election. And the Supreme Court, of course, dismissed our lawsuit on the basis of mootness. That is to say, too late, he was already elected. So those are the facts. And
excuse me.
I'll tell you what, I knew Steve, when you used that word. Dr. Vieira done talked about that. Go ahead, Dr. Vieira, give Steve your thoughts.
Well, the first thing that struck me as interesting here was the Secretary of State's initial response, I decline to investigate this because it's not ripe, which of course says to me that he's asserting that he really does have the authority to investigate it. So he solved the problem that I posed earlier as to where these people obtain their authority to engage in that process. He seems to think he has that authority. Maybe he could have been pressed to explain precisely what the source of it was. But I don't understand how the question becomes moot when the ineligible person finally achieves the goal of his conspiratorial behavior. That's the fascinating point to me. Crime does pay, apparently, in Washington State.
Yeah, well, it appears to pay nationwide, and this question of mootness, and this eligibility question. For instance, if there's some set of facts, suppose that you had a candidate who was required to sign a declaration of candidacy affirming that he was eligible to assume the office, and he refused, and he was elected. Would the Secretary of State be authorized to disqualify him? Or suppose that we had a candidate, for instance, the big question out here was the issue of Roger Calero, who's the Socialist Workers' Party candidate, who is clearly a green card holder, but who nonetheless was allowed to, I believe he was on 6 ballots for president across the country. Even though he's clearly constitutionally disqualified. And nonetheless, he didn't appear in Washington because he was required to sign a declaration of candidacy being a minor party candidate. But my question is, suppose that he refused to sign that declaration of candidacy and asserted his petition for candidacy anyway. Who would disqualify him?
Well, the Secretary of State would have to, because there was a statutory obligation on the part of the candidate to supply that document.
But the Secretary's argument is, and he made the argument in his responding brief, not only can we not disqualify him, we're prohibited from disqualifying.
Well, the man disqualified himself by not fulfilling state law.
You would think.
It's just a certification, in a sense, by the Secretary of State of what the record shows. The record shows the man was required to do this and didn't do it. End of discussion.
Okay, and
that would seem to be ministerial on the part of the Secretary of State. He looks at the record. Here's the consequence. The statute says so. He has no discretion there. That would be subject to a mandamus petition, for heaven's sake. I would think, I would hope.
Well, our
if I were the judge,
in fact, the mandamus petition. I mean, that's how we brought our writ, was for a writ of mandamus,
right,
requiring the Secretary to. The theory of our case was we brought a petition for a writ of mandamus requiring the Secretary of State to reverse the votes that were cast for Senator Obama on the basis that prior to the election, Senator Obama had not established his eligibility. And to this day, he hasn't established his eligibility. He has not proven, with any level of proof that is considered proof by a court, that he was born in the United States.
At a minimum. That's the minimum question.
That's the question of whether or not he can even establish if he's an American citizen.
That's right. Well, that's right, because then the next question becomes, what about his father's citizenship status and how that ties into the constitutional requirement. So quite obviously, if he can't establish that he was born in the United States, it seems as if he's out completely.
I think so. And our analysis is that because the 52 Immigration Act applied, if he was not born in the United States, Stanley Ann Dunham was too young to pass citizenship to him because she needed to be 21 under the 52 Act. She was 18 at the time of his birth. And even if the 66 Act had retroactive application, which it didn't, she would have still been required to have to be 19, which she wasn't. And in addition to that, the pleading was also made that because his father was a British citizen, he was a British citizen at birth pursuant to the 48 British Act of Nationality. And so he was a dual citizen at best, but if he was not born in the United States, he was not only not a United States citizen, but ineligible to become a United States citizen by mere election. He would have had to have gone through the naturalization process, and there's absolutely no evidence of that either.
Okay, Steve, you looked at that document. Can you tell us if it means anything?
Well, this is an interesting document, and the document, as far as I can tell, first of all, it's got applicability 90 days. This is an executive order from President Bush issued today. No, it's going to be issued tomorrow. Excuse me, January 16th. No, that's today, isn't it?
That's actually today.
All right, 3 days. And under this particular document, so this is effective today, but this is going to determine the fitness of individuals to perform work as employees.
Okay.
Or contractor employees for the federal government.
Well, would Barack Obama fall under that?
Probably not.
No, he's an officer.
Okay.
Yeah,
Well,
he's an officer, and this particular provision looks to creating certain fitness standards. Now, there's questions about who this. I mean, this is certainly going to have some application for as long as it's law anyway. This is going to have some application for could have application for sub-appointees. In other words, if the new Secretary of State makes appointments into the State Department, or if there's appointees into the Treasury Department or the Securities and Exchange Commission and so forth, that any of those employees are going to be subject to this new fitness scrutiny. Now, with that being said, part of this has a rubber stamp on it. That is to say, an employee who was once stamped with fitness is going to be forever stamped with fitness unless he moves up to a new level of security. And there is an exception for people who are in the intelligence community. And so it's arguable, even if it did have application for the president, as to whether or not the president would be subject to it on the basis of his access to intelligence, which, of course, he's the chief intelligence officer in the country.
Okay. All right, I'll tell you what, I want to bring this caller up right quick. Red Pepper, you still there?
I certainly am, man.
All right, what's your question for Steve or Dr. Vieira, whoever?
Well, I might have a little suggestion for Steve.
Okay.
This might be a different area he might be able to look in. Seems to me that everybody's been pretty much focused on his birth certificate and trying to get his school records and other records, but has anybody ever looked at his mother and father's divorce papers that would have the name of their child?
Oh, we got those divorce papers.
Great.
Yeah, we've looked at both the Soetoro divorce and the Obama divorce, and we have we've gotten copies of the final divorce documents, and I believe Ed has them posted on the Plains Radio Network.
That's correct. You can scroll down to the bottom of the chat box and click on any of those documents. All right, Chalice, I understand. Red Pepper, thank you for that call, my friend. All right, Chalice, I understand that you have a couple of questions from the listeners. Go ahead.
I do. I hope to get to as many of them as I can, Steve. CJ from Texas wants to ask you a quick question about the Bergs case. What does it mean that there is a document under seal, and what are the implications of that? I know that's a question that a lot of us have been wondering. I don't know if you're familiar with it, that in his current case, there's a one-page document that's under seal.
Yes. Now, a document under seal means that the document contains information that is protected. It could contain a private Social Security number, for instance, or some other data that for some reason or another the court has allowed for the document to be sealed. There have been new rules, because of the recent invasion of privacy that has taken place as the rise of the Internet. Privacy is diminished dramatically, especially after you put 840,000 cameras in a given city. That because privacy is diminished so much, that the question is what you can seal and what you can't seal has really become quite a tight issue. And a lot of the courts are allowing much more stuff to be out in the private eye and fewer things to be placed under seal. So it's probably fairly sensitive information. Could be a Social Security number or it could be the combination of a name, birth date, social security number. Those three would be protected as a matter of course.
Now, would they protect an entire document, or would they just take that out of the actual? Would that be a separate document?
That it could, depending on what the court rules are, it could be an entire document. In fact, it could be a voluminous set of documents.
I see. I guess we're all hoping it's the birth certificate.
Okay, let's go to Kenneth on line 3. What's your question for Steve or Dr. Vieira, Kenneth?
Hey, Ed, it's Kenneth. I got a couple of questions here real quick.
Well, you get one. Pick the best one.
The meeting at SCOTUS today with Obama and Biden, how is that possibly ethical when there's cases pending? And I wanted to get Steve and Dr. Vieira's position on that.
Dr. Vieira, what do you think on that?
Well, I think it certainly has the appearance of impropriety given the notoriety of the cases. Right? There's no way that these justices have not looked at those papers. There's no way they don't know that there's a serious problem as far as Mr. Obama is concerned. And if I were, all I can say is, who knows? You bring an ethics question before one of these Bar Association ethics panels, and you can't always be sure what answer you're going to get.